So, I miss the UK. I miss parts of the UK, of course I do. And I think that it's really quite sad that I won't be able to show, my children my homeland.
The courtroom fell silent as eyes fixed on Prince Harry, a moment meant for truth, suddenly turning unforgettable. Under oath, a judge asked a question so simple it should have passed unnoticed. The birth dates of his own children. Seconds stretched. Confidence cracked. Cameras captured shock rippling through the room as Harry struggled for words, igniting whispers, doubts, and headlines worldwide. Was this a harmless lapse, or something far deeper hiding behind the pause that changed everything, forever etched into royal history and public memory? A silence that spoke louder than any testimony. The question did not come with drama or accusation. It arrived calmly, almost routinely, carried in the steady voice of a judge whose role was not to provoke, but to verify. Inside one of the most secure courtrooms in the United Kingdom, on a Monday morning in London, Prince Harry sat under oath as a plaintiff, not a royal, not a public figure making a statement, but a man bound to answer plainly. The judge looked down at the papers, turned a page, and asked him to confirm the full birth dates of his two children, Archie and Lilibet. It was part of a standard identity and verification process, the kind of question designed to anchor testimony in certainty before more complex matters unfold. In that room, the expectation was immediate, not because the question was intrusive, but because it was basic. Parents answer such things instinctively, without searching, without hesitation. Especially here, where every word carried legal weight and every response was recorded, sealed, and weighed for credibility. This was not casual conversation. This was sworn testimony, and sworn testimony does not allow for guessing, improvisation, or delay. But the answer did not come. At first, the silence was almost invisible, just a fraction of a second, where no one yet realized something was wrong. Then it stretched, long enough for attention to sharpen, long enough for pens to stop moving, long enough for the air in the room to subtly change. Prince Harry blinked, glanced downward, shifted slightly in his seat. The judge waited. No one interrupted. No lawyer rushed in to clarify. The pause continued, no longer neutral, no longer harmless. This was not the kind of silence that reads as confusion. In court, silence carries meaning. It signals hesitation, uncertainty, calculation, or risk. And under oath, risk is never abstract. Every delay opens space for doubt, and doubt is the one thing a plaintiff cannot afford when credibility is the backbone of the case. This was not a hostile cross-examination or a trick question meant to trip him up. It was a procedural request, one designed to be answered cleanly so the court could move forward. Instead, the moment stalled. Those watching did not gasp or whisper. Courtrooms rarely react that way. The shift was quieter, more unnerving. A raised eyebrow here, a stillness there, the shared recognition that something expected had failed to happen. For a man whose legal battle depended on trust in his account of events, the hesitation felt heavy, almost symbolic, as though a fault line had briefly surfaced before anyone was ready to name it. Eventually, the answer didn't come. The dates weren't spoken. The court moved on. But the damage was already done, because the record does not capture only words. It captures timing, confidence, and the spaces in between. That pause could not be erased, corrected, or explained away in the moment. It sat there, embedded in the proceedings, marking the first crack in what was supposed to be a controlled, carefully presented case. In a courtroom, silence does not mean confusion. It means risk. And from that moment forward, every answer that followed would be heard through the echo of the one that took too long to arrive. So, what do you think that single frozen silence revealed about Harry, and could it silently change the course of his entire case? Stay with us. The moment silence turned dangerous. The pause did not end quickly. What had begun as a brief hesitation now settled into something heavier, something unmistakably serious. Prince Harry was not merely responding to a casual inquiry. He was sworn in, seated under oath in a sealed London courtroom, fully aware that every word and every absence of one carried legal consequence. This was a bench trial, not a media spectacle, and the rules were unforgiving. Truth was not measured by emotion here, but by clarity, consistency, and precision. And under those conditions, hesitation becomes something else entirely. The judge did not raise his voice. There was no visible frustration, no sharp rebuke. Instead, the question was calmly repeated, exactly as before, a procedural reset meant to give the witness a clear opportunity to respond. Can you confirm the full birth dates of your children? The repetition alone shifted the atmosphere. In court, when a judge asks the same question twice, it signals that the answer matters more than it first appeared. This was not about curiosity. It was about verification, identity, reliability. Prince Harry's body reacted before his words did. He blinked slowly, as though buying time. His gaze dropped to the desk in front of him. His shoulders shifted, a subtle adjustment that betrayed tension beneath the practiced composure. These movements were small, almost imperceptible, but in a courtroom, they spoke loudly. Lawyers noticed them. Judges noticed them. Silence, paired with visible unease, begins to tell its own story. And still, no clear answer came. This is the moment legal teams fear most: an unscripted gap. Courts are built on preparation. Statements are written, reviewed, refined. Witnesses are coached, not on what to say, but on how to stay within what they know. When a witness stalls on a foundational question, something no one anticipated, control slips away. There is no objection to raise against silence, no document to reference, no advisor allowed to step in. The witness is alone with the question. What made the moment especially fraught was what it suggested. This was not a complicated date buried in decades-old paperwork. These were the birth dates of his own children, Archie and Lilibet, details that sit at the center of his public narrative as a father and protector. Under oath, failing to provide that information clearly was no longer a human stumble. It became a legal vulnerability. Perjury does not require intent in the way the public often imagines. Courts examine accuracy, certainty, and consistency. A witness who cannot confirm basic facts introduces doubt into everything that follows. Even if an answer eventually surfaces, the initial failure does not disappear. It remains part of the record, unalterable, sitting between the lines of the transcript. Judges do not simply hear what is said. They remember how it was said and how long it took to say it. At that moment, this was no longer about memory alone. It was about credibility fracturing in real time. The silence lingered just long enough to change how the room listened. From that point forward, every statement Harry would make, every claim about timelines and impact, would be filtered through this hesitation. The case had not yet reached its central arguments, but something essential had already shifted, and the pressure, once it began to build, showed no sign of easing. Now, what cracks will this hesitation expose in Harry's case? And could one unanswered question change everything? Stay glued. Returning to a place he once tried to escape, to understand why that silence in the courtroom carried so much weight, you have to step back to the beginning of the day. Monday morning in London did not feel like a return for justice. It felt like a return to judgment. Prince Harry arrived quietly, without ceremony, without the protective layers that once defined every public appearance he made in this country. There was no Meghan by his side, no reassuring presence, no carefully managed moments for the cameras, because there were no cameras allowed. This was not a royal appearance, and it was not a media performance. It was a consequence. The location alone mattered. The Supreme Court of the United Kingdom is not a place of spectacle. Its heavy wooden doors and restrained architecture are designed to strip emotion from the room and leave only facts behind. This was the same system Harry had criticized for years, the same institutions he accused of failing to protect his family. And yet, here he was, walking straight back into it, voluntarily placing his story, his memory, and his credibility into its hands. As he stepped inside, reporters caught only brief glimpses. There were no smiles, no gestures, no acknowledgement. He did not pause. He did not look around. He moved forward with a stiffness that felt less like confidence and more like endurance. Dressed simply in dark gray, without medals or insignia, there was little left of the royal image the world once knew. What remained was posture, trained long ago, holding together a man who seemed emotionally distant from the moment unfolding around him. That distance was striking. It wasn't fear that showed on his face, but something closer to detachment, almost as if he had already accepted that whatever happened inside that courtroom was beyond his control. This was not the body language of someone preparing to win an argument. It was the body language of someone bracing himself to get through it, as though survival, not victory, had become the quiet goal. This trial was not Harry's first legal battle with the British press, but it carried a different weight. It was the final chapter in a long series of lawsuits aimed at confronting the tabloid machine he believed had shaped and damaged his life. Each case before this had chipped away at his sense of safety, his trust in institutions, and his belief that telling his story could still restore something lost. Now, standing alone inside the very system he once condemned, the cost of that belief was becoming visible. There was no protective buffer left, no palace officials, no public sympathy to lean on inside the courtroom. Once the doors closed behind him, Harry's story no longer belonged to him. It belonged to procedure, to verification, to the slow and careful weighing of credibility. That reality hung over him as he took his seat, even before the first question was asked. And when the judge's calm voice later broke the silence with a simple request about his children's birth dates, it landed on a man already worn thin by years of conflict. The hesitation that followed did not emerge from nowhere. It was born from this return, this reckoning, this quiet realization that he was no longer controlling the narrative. He was inside it, exposed, and everything he said next would be measured against the image he carried into that room. And how could a single question about his children's birth dates expose Harry's vulnerability and shift the courtroom's balance forever? Keep watching. When memory becomes the weakest link. By the time the court settled into its rhythm, it was already clear that this case would not turn on a single document or one explosive revelation. Its foundation was far more fragile. What Prince Harry had brought before the court was a story built on patterns, timelines, and recollections. A long chain of moments he claimed proved sustained intrusion by the British tabloid press. There were references to voicemails, tracking, private movements, and personal information appearing in print without consent. But at its core, this was not a case driven by physical evidence alone. It was driven by memory. That distinction matters. This was not a jury trial where emotion can sometimes sway the room. This was a judge-only proceeding, where credibility is examined slowly, methodically, and without sentiment. Every claim had to align, not just with documents, but with consistent recollection. Dates had to make sense. Sequences had to hold. One moment had to logically lead to the next. And in a case like this, where years of alleged intrusion were being revisited, memory was not simply supporting the argument, it was carrying it. The legal pressure intensified as that reality settled in. Each question posed to Harry was part of a larger verification process, designed to test whether his account could withstand scrutiny. Judges do not only listen for what happened, they listen for how clearly a witness remembers it. Certainty suggests truth. Hesitation invites doubt. And once doubt enters the room, it does not stay confined to a single answer. That is why the earlier pause over his children's birth dates mattered so much. It was not damaging because of what the question asked, but because of what it revealed. If a witness hesitates on a foundational fact, something deeply personal and seemingly unforgettable, it forces the court to reconsider how much weight to place on more complex memories. Timelines involving media articles, private conversations, or alleged surveillance suddenly feel less solid when the simplest details falter. In this case, Harry's recollection was central. His legal team argued that certain articles could only have been written through unlawful means, because the information was private and closely held. That argument depends on precise timing, when something was said, when it was overheard, when it appeared in print. If those moments blur, the entire structure weakens. Memory becomes the bridge between accusation and proof, and a bridge built on uncertainty is dangerous. What made this particularly risky was the cumulative effect. The case was not built on a single incident, but on a pattern. Patterns require repetition and consistency to be convincing. A judge looks for alignment across accounts, a steady narrative that holds its shape no matter where it is pressed. The moment memory begins to bend, even slightly, the pattern can unravel. And so the silence in response to the birth date question lingered beyond that moment. It became the first visible fracture, the point where the court saw vulnerability in the very tool Harry relied on most. From there, every recollection would be weighed more carefully, every timeline examined more closely. This was no longer just a legal battle over privacy. It was a test of reliability. In a case where memory is asked to carry so much, failure does not cause a gentle stumble. It causes collapse. And as the proceedings continued, it became increasingly clear that the court was no longer simply listening to Harry's story. It was measuring how firmly he could hold on to it. But what did that single moment of silence truly reveal about Harry's memory? And could it silently unravel everything he's fought for? Stay tuned. When his own words turned against him. The courtroom had already absorbed the tension of hesitation and doubt when the proceedings moved into a quieter, more intimate phase. Prince Harry was asked to read aloud from his own witness statement, a document carefully prepared, reviewed, and submitted as part of his case. On paper, these were his words, chosen to explain the emotional toll of years spent under relentless media scrutiny. Spoken aloud under oath, however, they took on a different weight. This was no longer a lawyer summarizing his experience. This was Harry himself, forced to confront his own account in real time. At first, his voice was steady, measured, controlled. He read the opening lines with the composure of someone accustomed to public speaking, someone trained to deliver difficult messages without betraying too much emotion. The courtroom listened closely, not because the words were new, but because context had changed. After the earlier silence, after the visible struggle to answer basic questions, every sentence now carried added significance. Then he reached the passage about memory. The pacing slowed almost instinctively, as if he sensed what was coming before he spoke it. The words described how ongoing trauma, constant intrusion, and fear had affected his ability to form consistent memories during the early days of his children's lives. As he read, his voice faltered, not dramatically, not enough to stop him, but enough to be noticed. A slight crack, a pause between phrases, the kind of hesitation that does not come from reading difficulty, but from recognition. In that moment, the earlier pause over his children's birth dates took on a new meaning. What had seemed inexplicable now appeared connected. This was no longer framed as a simple failure to recall a detail under pressure. It was being reframed, by his own words, as part of a broader struggle with clarity. The silence in response to the judge's question was no longer an isolated incident. It became a symptom. The contradiction was stark. Publicly, Harry had built a post-royal identity around being a fiercely protective father, a man who had uprooted his life to shield his children from the harm he believed the media had caused him. He had spoken often about safeguarding their future, about being present, about breaking cycles of pain. Yet here, under oath, he was acknowledging that those early moments many parents recall with sharp detail, were blurred for him. The courtroom felt the shift. Sympathy did not vanish, but it began to compete with concern. Courts do not punish vulnerability, but they do measure reliability. A witness can be wounded and still be credible, but when emotional truth begins to undermine factual clarity, the balance becomes delicate. Judges listen for consistency as much as sincerity, and this admission, however honest it may have been, introduced a new uncertainty into the case. The effect was subtle, but unmistakable. Harry was no longer being viewed solely as a victim of intrusion. He was being assessed as a narrator whose grasp on his own timeline might be compromised. That distinction matters deeply in a credibility-heavy trial. Once a court starts questioning not just what happened, but how clearly a witness remembers it, every claim becomes harder to anchor. As he finished reading, the room did not rush to fill the space with questions. The silence returned, but this time it felt different. It was reflective, evaluative, the kind of pause where understanding shifts beneath the surface. The birthdate hesitation, the admission of blurred memories, the visible strain in his voice all began to connect into a single thread. And as the proceedings moved forward, it became increasingly clear that the court was no longer weighing only the actions of the press. It was weighing the stability of the story itself. So, what could one tense pause, blurred memory, and strained voice reveal about Harry's story? And could it change the courtroom's balance forever? The calm voice that shifted the balance. By the time the next witness was called, the atmosphere in the courtroom had changed again, this time tightening rather than softening. The emotional weight of Prince Harry's testimony still lingered, but the proceedings were about to take a different turn. This was no longer about how the case felt. It was about how it held up. The follow-up witness entered without spectacle, without visible nerves, and without any need to persuade the room emotionally. She did not arrive as an adversary, but her presence immediately raised the legal pressure. She was a former assistant with professional ties to the publication at the center of the dispute, someone whose role placed her close enough to observe, but far enough removed to avoid theatrics. When she took the stand, her posture was composed, her tone steady. There was no visible anger, no defensiveness. She answered questions as if recounting ordinary facts, which, in a courtroom, can be far more persuasive than passion. Her testimony focused on a specific article published several years earlier, one Prince Harry's legal team had argued could only have been produced through unlawful surveillance. According to Harry's sworn account, the information used in that piece appeared shortly after the birth of his son, Archie, and there was no reasonable way the press could have known those details without intrusion. Timing was everything. The case relied on the idea that private information moved directly from Harry's personal life into print without consent. The witness's recollection disrupted that narrative. She spoke in dates and locations, grounding her answers in small, concrete moments rather than broad impressions. She described overhearing sensitive details during a private lunch attended by freelance journalists, a setting where information was discussed openly, not secretly obtained. There were no recordings, no hacked messages, no intercepted data in her account, just conversation. More importantly, she placed that conversation earlier than the timeline Harry had sworn to under oath. The contradiction was subtle, but its implications were serious. This was no longer a debate over how intrusive the press could be. It was a question of when certain information became known and how it traveled. Earlier, the court had watched Harry struggle with hesitation, searching for clarity on basic personal facts. Now, this witness, with far less emotional investment in the outcome, recalled specific sequences with ease. She did not need sympathy to sound credible. She needed only consistency. This is where legal pressure reaches its peak in a judge-only trial. Judges are trained to weigh demeanor carefully. Emotional testimony can explain motive, but calm testimony often establishes fact. The witness's steadiness invited trust, not because she seemed flawless, but because she seemed unburdened by the weight Harry carried. Her recollections did not feel defended. They felt recalled. As she continued, the gap between the two accounts widened. Harry's case depended on memory shaped by trauma, by years of conflict with the press. Hers depended on routine professional exposure, the kind that leaves dates and conversations neatly filed away. Neither approach is inherently dishonest, but in court, clarity often outperforms conviction. The room sensed it, not through reaction, but through attention. The judge listened closely. Lawyers adjusted their questions. Each answer added quiet pressure to Harry's narrative, not through accusation, but through contradiction. The case was no longer balanced between privacy and intrusion alone. It was balanced between two versions of time. And when memory stands opposite memory, the one delivered calmly, without strain, tends to carry more weight. As memory clashed with memory and calm testimony outweighed Harry's, could one quiet contradiction silently topple his entire case? The moment everything slipped. The courtroom had settled into a tense hush, the kind of silence that presses on the chest, heavy and unyielding. Every eye was fixed on the witness who, for a moment, seemed to carry the weight of the entire trial in her shoulders. When the judge leaned forward and asked her to clarify one detail, the room waited, collectively holding its breath. She paused, looked directly at the judge, and then spoke. "I don't think he remembers saying it." Those words hit like a hammer. Across the room, Harry's hand froze mid-gesture. His pen, the small tool that had accompanied him through every meticulous note and careful answer, slipped from his fingers and clattered onto the polished wood. It was a quiet sound, almost trivial, but in that courtroom, it screamed defeat. To the untrained eye, it was just a pen falling. But for anyone paying attention, it was a symbol. Control, however fragile, had evaporated. In a bench trial, where there is no jury and every decision rests solely with the judge, consistency is everything. A lawyer's carefully prepared arguments, a client's rehearsed recollections, all hinge on appearing coherent and reliable. The moment Harry could not account for a single line of conversation, the judge was forced to confront a glaring inconsistency, not the emotional strain behind it. Pain, stress, or personal turmoil do not weigh on the scales here. Only credibility does. And in that instant, credibility faltered. The courtroom seemed to shrink around him, every detail suddenly sharper. Harry's carefully constructed narrative, the one he had labored over for months, was unraveling not because of scandal or sensational headlines, but because of one simple, unyielding truth. Memory had betrayed him, and in a bench trial, that is a defeat that cannot be mended. What followed was subtle, almost imperceptible to the casual observer. The judge continued with measured questions. The witness remained composed, and yet the shift had already occurred. Authority, the quiet force that underpinned every statement Harry had made, had slipped away. He didn't just miss a beat. He lost control over how his story would be received, how it would be believed, how it would stand under the piercing scrutiny of the law. Outside, the media might have spun their narratives, painting the drama in sensational colors. But inside the courtroom, it was far more profound. This wasn't a question of tabloid headlines or public opinion anymore. It was a question of fact versus falter, of whether the court could trust the man at the center of it all. And as the witness's words echoed in the silent chamber, it became painfully clear. For Harry, this moment was no longer a minor stumble. It was the line that no lawyer, no amount of preparation, could ever undo. So, what do you think caused that courtroom silence? Pressure, memory, or something darker? And what does it mean for Harry's case? Share your thoughts in the comments. Don't forget to like, share, and subscribe.